Welcome back, and we are moving to our second conversation for today. This is a very important one. We really want you to listen up. Send your questions in on Facebook if you have them, because we are going to be discussing the International Court of Justice, its role, relevant cases, and a record of compliance. We have with us on set two members of the Referendum Commission. We're joined by historian Herman Byrd and Dr. Gilda Lewis, who is a retired associate professor. Good morning and welcome.
Thank you very much.
It's so nice to have you in. The conversation is definitely one to reckon with. Reason being is because it is the hottest topic that is out there. And of course, you guys could start wherever you find it fit, so we could get the conversation moving on.
Well, I want to start off with a specific question, just in terms of your decision to be a part of the Referendum Commission. Let's start there with you.
Well, I think it found me rather than I made a decision to be, because I've been involved with this whole Guatemala thing since 2000 from the National Advisory Commission.
Yes.
And when it became the ACGC, the Advisory Committee, they kept me on. I didn't argue with them. And then when it became the Referendum Commission, they kept me on, and I didn't argue with them again. So I have that background from then, right? And I've been researching all that time.
Okay.
Mine go back that far also. I first became involved when I was Dean of SJC Sixth Form many moons ago. And my predecessor, the distinguished Sister Mercy Cervantes, had served on the Advisory Commission.
Okay.
And so when I took over as Dean, I found this letter from the Ministry of Foreign Affairs appointing me to this commission. And I've been with the commission as it's gone through various variations over the years in trying to share whatever knowledge I can in the effort to settle this.
So we both have our long service medal.
You do, but I do have to say, and I'm sure from your extensive experience, the conversation has changed tremendously about the Belize Guatemala issue. Where it used to be more of a historical decision, now it's a real life tangible matter for people. So what has the past, I'd say 2 years or more been like, since having the conversation out in the open, where the concerns, the misconceptions, and even some of the challenges that people bring forward to you are perhaps a lot more passionate than they used to be?
Well, all we have to do is to stay rooted in what the ICJ is and how it works, how it arrives at its decision, because there's a lot of disinformation. Misinformation, I like my dictionary, right?
Yes.
Yes.
Information is you got the facts.
Yeah.
Misinformation is you got the facts, but you're twisting them around because maybe you don't understand. But disinformation is you have the facts and you're deliberately twisting it and turning it to suit yourself.
I think what has changed also is that we're moving towards a juncture where you can get. Just to add on that, one other aspect in terms of Belize responding to any claim on cession is part of the statute says the court shall apply fundamental principles of international law.
Yes.
And one fundamental principle is that you can't cede what you don't have. So in one of the earliest studies on the dispute by a man named Louis Bloomfield in 1951 or 52, the book is called The British Honduras Guatemala Dispute. This is one of the points that he raised, that he pointed out that by the time Spain recognized Guatemala and sovereignty in 1863, she had already lost, not just Guatemala had already signed away whatever she could have been ceded to her, and Spain had never had anything to cede. And this fundamental principle is you can't cede what you don't have. And this is acknowledged by the Guatemalan foreign minister himself. They suppressed for many years a declaration, a rationale explaining why this was a good deal by Pedro de Asenena, in which he said, listen, even if we had any rights, the fact is that the area was abandoned by Spain and by us.
So
we were never able to settle it.
They come under item B then.
And the part that I like working at the archives is that he says that we did this after scrambling through the old archives of the Audiencia of Guatemala and couldn't find any evidence to support this claim, even if we wanted to. So that is a fatal blow, I think, to any claim of cession coming from the person who has that, who is expressing the sovereign will of Guatemala at that place and time. So again, our defense is going to be multi-layered, but on many fronts.
But there are historians that would say all the way back as well, while Guatemala is saying that they ceded land, is because they actually gave Mayans, their Guatemalan, what do I say? They actually claim the Guatemalan, the Mayans, and say, you know what, these people are Guatemalans actually who lived up in this particular area that they're now they have claimed. How do we deal with this?
So they have to prove that. You can say anything, you know, but when you get to the ICJ, it's not what just you say, it's what you can prove.
But also the point there is that kind of goes into the ambit of fairness and equity, because we have citizens there. Therefore, I mean, in Libya, Libya was saying that we have ties to the indigenous people going back to the Ottoman Empire in the 13th and the 14th century. That was disregarded by the court. But one of the great achievements of the special agreement is that it rules out any appeal to any kind of fairness and equity kind of an argument. So their lawyers will not entertain those kinds of, they have their reputation to think about, they're not going to entertain those kinds of claims. They will be struck out. I mean, one of the issues, the role, the status of indigenous people in international law, that's a whole nother issue where there's considerable work being done, but in terms of using that as a basis for claim.
So what you're saying is the idea that the Mayans who lived in Belize centuries ago may have been Guatemalan citizens. That would be a claim made under fair and equitable causes, more so than international law.
Yeah, there's no sound basis to do that. And even when you look at all of the authorities who have looked at Belize during the colonial period would say that Mavis Campbell's recent book, Belize, an Outpost of Empire, Belize remain on the fringe of, even though the Audiencia of Yucatan had tremendous control over Belize, Belize essentially remained on the fringe of both Guatemala and both Honduras and Yucatan throughout the entire colonial period. If we could have been, there are many instances when we could have been incorporated into either one of them. It never happened. And so the Maya remained and lived as an independent, autonomous community. They really were not under the control of Guatemala. Well, so that's just the historical record, not to mention the
Maya people voted with their feet. They chose to come here because what they left over there was much worse than what they would find here.
That's a whole other history lesson we don't have time to get into right now, but I do, one of the critical points, and we were talking about it during the break, it's looking at the rules and regulations, Article 38 for the ICJ, and looking at how international law is measured, and it's actually a step-by-step basis. So we'll try to get back to that, but the first area that will be looked at is the international conventions, right? So explain to us how, there it is.
That is a treaty.
Okay, so explain to us how this works.
That is the 1859 treaty.
Yeah.
And that treaty, like I said, it says boundary. Where the ICJ finds a treaty that is valid, that's why I put first round knockout there. Because they don't,
in your mind,
go any further,
one.
case done, right? So
they would first look at the validity of
the treaty.
The legal validity of a treaty.
Right.
Right?
Yes.
Right.
And as you have said, because it is a boundary treaty,
right,
not necessarily with conditions set with this cart road, just agreeing to boundaries, and we'll also build a cart road, that is valid as is, that you feel that the court would rule that way.
In doing that, another aspect of the convention, in doing that in terms of applying the rules to interpret a treaty, the court also applies a well-established convention, which is the Vienna Convention of the Laws of Treaty, which courts and tribunals all over the world use to interpret a treaty. And they often go to one or two of the main articles of that treaty, which says that we should interpret a treaty based on the plain language and terms of the treaty, in terms of its context and object and purpose of the treaty. Right. And it doesn't matter if you have ratified the Vienna Convention or not. The court will still apply this because these tools for interpreting treaties are part of customary international law.
Okay.
They apply to any country, irrespective of whether or not, I mean, this was 1969. We haven't signed the Vienna Convention of the Law of Treaties, but that doesn't mean that those principles will not be applied in our case.
Okay.
But when you read an ICJ judgment, and you have to have the time because the Cameroon, Nigeria is about 400 pages.
Wow.
Right? But I shortcut it by telling my computer to find the word court. And anytime I drop on court, I see what the court was saying, so I don't have to go through everything.
Yeah.
In the Cameroon-Nigeria case, Nigeria was saying that they had people living in Cameroon because there was the war in 1968, and their people fled to Cameroon.
Yes.
And they didn't go back to Nigeria. So by the time they were in court, about 3 million people from Nigeria were living in Cameroon. And Nigeria had built school and clinic and all of that for them and fly the Nigerian flag. So they go to the court trying to claim sovereignty because they were administering those areas of Cameroon. The court said, wait, hold it. Cameroon protested. They didn't sit back and allow you to administer their countries like you own it.
Yeah.
Spain didn't protest. Guatemala didn't protest. We were here for all that time.
All the time.
And in that case, there is an important sentence that the court said. These people had this thing that has been giving them a problem for all these years. And then it's a matter of treaty and boundary and all of that. The task of the court is not to delimit the boundary de novo, which means from the beginning, nor to demarcate it. One sentence, like a gold nugget, right? The limiting is what we have in the 1859 treaty. The demarcating is when you put down the cement pillars.
Yes.
We have partial demarcation between Gabas Falls and Gracias a Dios, which is under the ground. At intervals, it was marked off, and they put some markers under the ground, put piles of stone on top of each marker. The piles of stone have already become a Guatemalan person's fence, okay? But what's under there is there, so that can be easily found.
Yes.
Yeah.
And then the other part of the demarcation has to be from Gabas Falls due north to the Mexican
Mexican
boundary.
border.
So part of the work is finished. Then you have to find the money to get the materials for the cement markers and
Yeah.
Belize will get some jobs out of the demarcation too, right?
Yeah. So we were saying that, and you call it a first knockout. This is your analysis of
Yes.
it. So the first look is at the convention and the legality, but then we move into international custom, right? Explain that to me.
That is, to put it how Belize would understand it, squatters' rights. In Belize, if you own a property and you abandon it, and someone goes in there and lives in it for 12 years,
Okay.
you can't put them out. It belongs, and you have not been protesting. Now you must protest, right? But if you have not been protesting for 12 years and this person is in there, you said nothing, that person can get. There was a case recently in court with that same squatters' rights thing. And so that is what that item B is all about.
Which pushes
And
us way above.
Yeah, and it also includes an element of not just the physical squatting, but the squatter acting as if it's his or her own, acting as a sovereign, carrying out exercise that a sovereign would do, mapping, passing laws,
collecting taxes.
We have evidence of in the 1820s of court records of the extension of criminal jurisdiction to the mouth of the Gorda, the old name for the Sarstoon. That's the kind of thing that sovereign do in an area that belongs to them. All right. So that's part of the evidence I think that we will see.
Yeah. And then going back, then we move to the general principles of law. Yeah. But we'll bring up the slide, don't worry. Yeah, the same previous slide.
Okay.
So that says recognized by civilized nations, and we do have precedents in similar circumstances. The ICJ always refers.
Oh, it refers back to its precedents,
Yeah.
how it ruled. Look, those people don't talk with forked tongue, you know. If you read an ICJ judgment, they keep referring to similar situations where they ruled a certain way, and they end up ruling the same way
Exactly.
because the circumstances are similar.
So the judgment is, the operative part of any judgment is binding in that particular case, the delimitation and the demarcation that it rules on, but the principles that inform that delimitation or demarcation, that becomes part of the body of international law. And the thing, one of the things it's important to say about the ICJ, there is no hierarchy of international courts and tribunal like we have from magistrate to court of appeal to the CCJ, but the ICJ is generally accepted as being at the apex of international courts and tribunal. So much so that if any other international court disregarded a clarification of international law from the court or a ruling, a decision of the court, that tribunal or court would jeopardize its own credibility in short order. So that speaks to the status of the court in a system where there is no hierarchy, the recognition of that. No?
So in other words, it's the end all. That's as high as you can go.
Exactly.
No other court
No other court
would
matches,
usually.
Yeah. And there are quite a number of international courts operating across the world.
Yeah.
But again, like I said, they all look, when it comes to clarifying matters of international law, they look to the ICJ, and particularly if you're dealing with territorial and maritime dispute, this has developed as a special forte of the court.
Right.
It has settled more such disputes than any other court or tribunal, and so when you have an example I gave, for example, the Barbados-Trinidad fishing dispute, for many years that was settled not by the court but by arbitration. Okay, but the principles that were deployed there was the UN Convention of the Law of the Sea, and they look back on how the court had dealt with delimiting exclusive economic zones, and they used that as a guide. So, and that's a case where the parties choose their own judges, and they can apply their own law. All right, they don't have to do this. There's a Guyanese jurist by the name of Mohammed Shahabuddin who wrote, I think, the only existing book on the precedents of the ICJ. And he does say that, listen, in international law, precedents, they're not binding. But he says when it comes to this court, all right, it has the stature to refer constantly to its own precedents, all right? And they have become highly persuasive and in many cases binding. So that's from, like I said, the authority on this issue of how the court has used precedents.
Now, binding means that it is agreed upon by both countries and everywhere.
Binding means that the majority of the court has ruled.
Yes.
And you are bound to comply with that ruling.
Now, enforcement is a different issue.
That becomes a matter for the Security Council if need be.
Okay.
After the Libya-Chad war, and Chad won, Chad, but incidentally, waited 17 years before going to court. Right? And at the end of that period, they start with the Organization of African Unity, then they went to the General Assembly about 8 times and the Security Council about 4 times, and no resolution because Security Council statute says that you should go to the ICJ anyway. So they went and they won. And after they won, Gaddafi said he would not accept the ruling. But the United Nations Security Council stepped in and monitored, because the ruling said they must withdraw their troops, both sides. And they monitored the troop withdrawals for 6 weeks, and after they certified that yes, all the troops are out, then Libya complied. So it took them 6 weeks. It took Nigeria 4 years to comply.
So let's use the Belize example. Let's say come April, Belizeans decide to agree to go to the ICJ. The case unfolds over the years and the processes that we have started to explain, and the ruling is clear. Belize will continue to exist as the Belize we know. And Guatemala says, I don't want to respect it, I don't want to agree. Give me then what the options would be for Belize.
The framers of the special agreement thought long and hard about that and addressed it, I think, very clearly in Article 5. If they can show that slide, I think that's a very important slide for Dr. Lewis to comment on.
Yeah, we'll get it. So this is Article 5 of the special agreement?
Yes.
And it is where it speaks of the binding.
The binding and the boundary commission.
All right, there we go.
I call that the prize because we will win the prize, okay?
Yeah.
And there's been a lot of noise about the question that the voters are going to be asked and the request that is going to be made of the judges and all of that, but people are losing sight of the prize.
Yes.
Within 3 months of the judgment, the boundary commission must be appointed by both sides. And if that doesn't happen, either side can go to the OAS and say, please appoint the boundary commission, set this thing up, and let's get moving.
Yeah.
Once you have the judgment, but you have to have the judgment.
And whatever the decision is final and binding, as agreed upon in 2009 with the special agreement, the compromise.
And the other thing, once we have that special agreement, which is what opens the ICJ door so we can go there, right? In the Cameroon-Nigeria case, they were already in court, and Nigeria was still attacking the Cameroon troops.
Wow.
And Cameroon applied to the ICJ for provisional measures, which is like an injunction in our local. And they got the provisional measures. So I am saying, once we get through that ICJ door. We're there. And the GAF still continues playing the fool down south. We go and we ask the ICJ for provisional measures. And they tell them, stand down until we finish with this case and we have our judgment. There are so many benefits to going there that we're not really exploring, right? So if we don't go there, we have to deal with the GAF. We have to deal with the land border. I checked the census figures for 2018. The P10 census population is more than double the entire population of Belize.
Just the state of P10?
Just P10. So you have all those land-hungry people over there and our attractive jewel that they want. And who will stop them if we don't have a judgment?
So the difference between, and I want to make this clear because, we've heard people complain, and rightly so. We are all frustrated as Belizeans with what we see happening in the Sarstoon. And so many have said, why can't all these other friends of Belize step in and say now, stop overstepping your boundaries, Guatemala, don't come into Belize's waters.
They're all bound by the ICJ, and they're the judge people.
So they cannot say, they cannot intervene.
They can talk behind closed doors, but they can't force anything. When I first started hearing about we need a Sarstoon protocol, we should not go to the ICJ if we haven't already gotten a Sarstoon protocol. And I'm saying, that sounds like domestic violence. The woman is getting beaten every day. The family court is there, but she isn't going to the family court until she stops getting beaten. It doesn't make sense, right? So once you get through that door, you can stop the beating now with a provisional measures judgment from the ICJ.
But throwing on that, there is a police force, and you make a report. Now, it still brings me back to Guatemala. We see them, the GAFs, encroaching into our land space. They come as far as probably around the Barranco area, which is clearly Belize. And people are saying, why is nothing being done? Even though that we're a part of the UN, they are part of the UN, we've got the Organization of American States, and we do make complaints. Why is nothing being done there?
It has to be of global implications for the Security Council to get involved. And I take you back to the situation with Gaddafi and Libya, when the Security Council decided that they would apply military force and they got rid of Gaddafi, right? But Libya is a strategically, globally important place with millions of people that were going to be slaughtered. And even then, Susan Rice had to really work behind the scenes to get that through the Security Council, because one veto in the Security Council kills the whole thing. So she managed to get that through the Security Council without a veto. Now, if Guatemala overruns Belize, we are so important that the Security Council is going to pass a resolution and come to our rescue after the UN has already told us that we need to settle this thing. You know, every time
it's like going against. I'm trying to find a way to kind of tie. It's going against your own system. It's like I am within the court system and I'm making a decision without telling you, please take it to the court.
Right.
You know, I think one of the things that people battle with the most, you call it the prize, but I say that's really the biggest concern for Belizeans here. Without thinking of the actual decision-making process, if we lose even that blade of grass, we're also bound to it as well.
Yes.
And that's a real fear that Belizeans have. So with all the history and knowledge and understanding that you have, how do you put that fear at ease for a large number of Belizeans?
Well, remember, I told you I had my fear when I was banging on the table.
Yes.
Before I really got involved and before I really started looking at cases and so on. I don't have any doubt from how the ICJ operates that our treaty will stand. And once the treaty stands, then everything follows logically from that.
You know,
I just want to say too is I think it's important to, I mean, it's a difficult thing, and I have obviously my own concerns also, but the issue is that when you look at Belize's response to any Guatemalan claim, it's not just, all the eggs are not in one basket. It's a series of interlocking kind of position that the court has time and again held up in other cases, that it would have to find compelling reasons to set aside its own. It would be overturning its own jurisprudence, which that's anything is possible, I guess, but it would be highly unlikely for that to happen. That gives me tremendous comfort.
But I think the problem is sometimes that we question the motives of Guatemala as well. And so when we talk historically about...
Find Gert Rosenthal.
They'll find it. So, you know, when we talk about Guatemala's hesitance in going to the ICJ strictly on international law over the years, and now a change in position in agreeing to do so, you know, you're in a battle. I start to say, okay, what's the motive of my enemy so I can prepare? In other words, they must feel they have a solid case as well.
Behind the closed doors, the international community has been working on Guatemala too. Okay? And I when somebody asks me that question, I say, he who rides the tiger is afraid to get off because he's in danger of being eaten by the tiger, right? So Guatemala has spent generations telling its people, Belize es nuestro. They cannot go back and say, perdóname, I don't have all the Spanish, but pardon me, I was telling you a lie the whole time.
It would be political suicide.
They might get actually killed.
And I like that.
Let's get Byrd to share.
No, I was going to say that some of the diplomats have put it this way. Both no Guatemalan government can come back from a negotiation and say listen, we've settled this thing, but we don't have anything for show for it. By the same token, no Belizean government can come back and say we have settled this thing by giving up something, giving land or something like that. So that's a situation that both sides.
And they will get something out of an ICJ judgment, because right now they have no international waterway out from Guatemala, right? They are locked in by Belize and Honduras.
Yeah.
So coming out of the ICJ under the law of the sea, Guatemala has to get some maritime boundary established for Guatemala. In the facilitation process, both Belize and Honduras were willing to give up some of theirs, more than what Guatemala will get under the law of the sea. Guatemala would have gotten economic zone and all of that. But they chose not to accept the facilitation process. But under the law of the sea, they have to have access. So once that judgment is in place, Belize will have to amend its constitution because our maritime area is not defined in our constitution, right? We talk about keys, but you don't know which part, right? So the law of the sea will define that all over the Caribbean, you know, these islands that are close to each other,
overlap.
they're going to the law of the sea to find out, you know, what is your piece and what is my piece. And this is the way the international world works. But this is not an island. We're part of an international community. And we have to behave like we are members of that international community.
And I wanted to say with respect to the maritime, sometimes we forget that that's a dimension of the dispute also. We're focusing so heavily on the land. The other key point there is that we're all 3 countries in the Bay of Honduras are signatories to the Convention of the Law of the Sea.
Right.
So we all are entitled to those new maritime entitlements that came with that ratification. The 12 miles of territorial sea, the 24 miles of continental shelf, the 200 miles of EEZ. But there is always a provision, if there is space in the sea, the geographical configuration of the bay makes it impossible for all states to claim full entitlements. The convention itself says
go to
that
the median line.
you should, they have a principle that you should go to the median line and that you should try to do it by talking. But if you can't settle it by talking, built into the Convention of the Law of the Sea is some annexes for judicial settlement of those disputes. And when you sign on to ratify the convention, you have to for which one of those you're going to use in the event that you can't settle any kind of overlapping maritime right. Are you going to choose the ICJ? Are you going to choose the International Tribunal of the Law of the Sea? Or if you have, and they even have a provision, if you don't choose any of them, it means that you have selected the default option, which is arbitration. Via arbitration. So there's a recognition even within the Law of the Sea that because of the complexity of these maritime entitlements, they may not be able to be resolved through diplomacy. And you might have to go to a third party to actually make the call. And that's where we have been the efforts after the facilitation process to come up with a maritime agreement failed considerable. We just flounder simply because of some key principles there.
The ICJ is like a one-stop supermarket. Right? You go there, you can get your land and your sea all at the same time.
But what if people say, we're putting all your eggs in one basket?
But we're not, in the sense that in terms of our response to Guatemala claim, we haven't even touched the issue of our right to self-determination and territorial integrity, which puts the whole dispute in a completely different category. And that is
that's actually the third. We spoke the treaty. We spoke of acting as a sovereign nation, and the third is self-determination.
Exactly. That puts the dispute in a completely, that all of a sudden it jettisons all of those other things, and the court then focuses on what happened on September 21st, 1981.
Which is we became a sovereign nation.
Within the existing boundaries that we have.
Recognized by every other country except Guatemala.
Except one, okay. And
Guatemala was the only country that voted against Belize in 1981, you know. And they said to the UN, you can say what you want and you can vote how you want, but we are telling you that Belize is in our territory and we are going to get it back.
Final for me.
No, I just wanted to say on the principle of the right to self-determination, Belize has not been obviously at the ICJ before, but we have participated in 2 very important advisory opinions. The one on the Palestinian wall and just recently the case in Mauritius. In both instances, Belize was very strong in upholding this right to self-determination and the decision of the court, advisory though it may be, will turn on further development of that very same issue. All right, so that is, and time and again, the court has said, has states to intervene when they're intervening on the basis of trying to hold on to some pre-colonial ties that they had. No, we're in a completely different era.
And the other thing with that 1981 resolution, which they had said before, and they repeated it there, that Belize and Guatemala are to vigorously pursue negotiations aimed at a settlement. So though they were supportive of us, they're telling us that we must get this thing settled. And how can we get it settled? Where can we get it settled? Not in the Supreme Court of Belize, in the Supreme Court of the world.
All right, I think we have covered it all. There's still a lot more to discuss.
Yes.
Don't
Invite
be
us back.
mistaken, but this is this portion of the conversation. Thank you so much for
When
coming in.
when you have us back again, we can take up where we left off now.
Yeah, absolutely. Thank you for coming in.
Thank you very much.
We're going to go ahead and take our final break, and when we come back, we'll have a wrap up, so stay tuned.